Hi guys, my name is Mackenzie Garreau, and I have topic 5, which is competence to refuse an insanity defense and other mental state disorders. So we're just going to get right into it. So here's some background on this topic. The state has traditionally been accorded wide-ranging power to make decisions for those unable to care for themselves under what is known as parens patriae, which is a Latin term for the state's paternal and protective role over its citizens or others subject to its jurisdiction authority. However, a large portion of Western civilization has upheld the idea that respect for individual liberty is a need for human dignity since the middle of the 19th century, unless there are compelling reasons to do otherwise. According to this premise, the state shouldn't use its parens patriae authority to interfere in someone's life unless, at the very least, the person is incapable of carrying out the particular act or decision in question. Therefore, decisional competence is a crucial forensic issue that is frequently overlooked. So, this presentation will examine the following decisional competence issue of competence to refuse an insanity defense. So, a little introduction on this topic. A variant of decisional competence arises when the defense attorney, the prosecution, or the court believes that a defendant may have been insane at the time of the offense, but the defendant does not want to assert such a defense. An identical circumstance occurs when the defendant is in a capital case objects to the presentation of a diminished capacity defense at trial or to the introduction of mitigation evidence in a criminal process. The question we need to ask here is, does the court or the defense attorney have the authority or perhaps even the duty to raise these defenses over the defendant's objection? And so here's some important cases connected to this topic. So one line of cases is illustrated by Whalen versus United States, in which Judge Bazelon, writing for the Federal Court of Appeals for the DC Circuit, appeared to require trial judges to impose an insanity defense when the defense would be likely to succeed. One of the major foundations for the structure of the criminal law is the concept of responsibility, and the law is clear that one whose acts would otherwise be criminal has committed no crime at all if, because of incapacity due to age or mental condition, he is not responsible for those acts. In the courtroom confrontations between the individual and society, the trial judge must uphold this structural foundation by refusing to allow the conviction of an obviously mentally irresponsible defendant. And when there is sufficient question as to a defendant's mental responsibility at the time of the crime, that issue must become part of the case. Thus, the Whalen formulation highlights the need for society to avoid convicting someone who is morally innocent. The defendant's interests would not be dispositive, even though it allows judges to consider them at their discretion. And here are some more important cases on this topic. Frendak v. United States requires that the defendant's decision regarding assertion of the defense be followed when the defendant is competent to make it. Another case is North Carolina v. Alford, which held that a competent defendant is permitted to plead guilty even when denying guilt. The Frendak court concluded that respect for a defendant's freedom as a person mandates that he or she be permitted to make fundamental decisions about the course of the proceedings. And then the court noted several reasons why a defendant might choose to refuse an insanity defense. An insanity acquittal may result in a longer period of confinement than would conviction. The defendant may believe that better treatment will be received in prison than in a mental hospital, and this is continued. The defendant may wish to avoid the stigma associated with mental disorder. Commitment to the mental health system may result in collateral loss of legal rights, for example, the ability to obtain a driver's license. And the defendant may view the crime as a political or religious act, which an insanity defense would negate. As a result, Frendak restricts the question of whether a defendant can reject an insanity defense to examining the defendant's capacity to do so. Frendak is clearly the majority view right now. Indeed, the Whalen case itself was overturned in United States v. Marble, but a few jurisdictions still adhere to the Whalen approach. Some trends in this topic. The presentation of mitigation evidence at sentencing is similarly divided. Despite compelling arguments that society should have the authority to overrule a competent individual's decision to forego mitigation evidence, at least when the death penalty is at stake, the obvious trend is for defendants to be allowed to do so. The trend is somewhat less evident when counsel or the court wants to assert other mental state defenses over a defendant's objection, if only because very few cases address the issue. The evaluation scope will be similar to a standard assessment of the defendant's mental state at the time of the offense in those jurisdictions that permit the imposition of a mental state defense over a competent defendant's dissent. The main question is whether the evidence supports a viable defense, though the defendant's jurisdiction for rejecting the defense may be taken into consideration. On the other hand, in a Friend X style jurisdiction, the nature of the evaluation will be similar to that required to assess competence to proceed. The Supreme Court would probably hold that a person who is competent to stand trial is competent to waive the insanity defense. And here are some final findings. Even if competence to waive an insanity defense is equated with competence to proceed, the waiver must be voluntary and knowing, as is true with competence to plead guilty and to waive the right to counsel. Whether the defendant's decision making is so impaired that a finding of incompetence to refuse an insanity defense is warranted is, of course, a matter for the judge to decide. As with guilty pleas, courts may follow Bonnie's suggestion and require more for a valid waiver of mental state defenses when the waiver is against the attorney's advice. Others, on the other hand, contend that even if a defendant displays signs of a mental illness, their waivers should typically be accepted if they are aware of the risks and advantages associated and reject a mental state argument for one of the grounds listed in Friend X. In my discussion question for this, to what extent should a defendant's competence to refuse an insanity defense be determined by their understanding of the legal consequences versus their understanding of the factual elements of their case? In situations such, a defendant may not fully grasp their own mental illness, but understands the legal implications of the insanity defense should they still have the right to waive it. This is a loaded question and maybe two questions in of itself, but I think it's a very good question to ask after learning about this topic. And so my outside source that I picked, I chose an article from the National Library of Medicine, and it addresses the issue whether mentally ill defendants charged with serious crimes who refuse to plead a viable and counsel recommended insanity defense for delusional reasons should be considered to be incompetent to stand trial, whether such defendants should be allowed to represent themselves with a delusional defense, and whether an insanity defense may properly be imposed upon such defendants. This is a long read, but I do really like how it goes into depth more about my topic, and I recommend that everybody give it a read, as it does go a little bit more in depth on my topic and shines a little bit of light more on competence and incompetence. And so here are my resources that I used.